Good morning, fellow members. It's the appointed time and we've formed a quorum. Let's call the meeting to order. Mr. Ju, what is it? Madam Chair, previously I've talked to you and asked whether we have the opportunity to really take a look at an issue. And also, we haven't visited the Shek Kong stabling sightings. Well, maybe, please consider this. Well, we should visit this area of the WKS. There are media reports saying that you would draw a line today, and I'm very worried. There should not be such a thing happening, right? This is something unheard of. Is that true? Well, I will deal with it in a moment. How are you going to deal with it? In a minute. Well, you cannot do whatever you like and draw a line casually. Well, let's wait for the administration team to join us before I explain the work plan. Is it your personal work plan? I will be explaining to you the Bills Committee's work plan. I will propose a work plan for the work of the Bills Committee. Good morning, Secretary and government officials. A warm welcome. Fellow members, this is the 12th meeting of the Bills Committee. We have held 11 meetings, excluding the 2 public hearings. And last time, we've started to scrutinize clauses 1, 2, and 3. And I hope that we can finish clauses 1, 2, 3, and 4. Well, let me finish first. Last time, 7 members are on the waiting list to ask a question, and one of them has already asked 3 times. Any other member who would like to ask a question? We are done with the first round of questions. You weren't here last time. You weren't here in the last meeting. Let me try to explain the work arrangements here. Now, since there is a special FC meeting next week, so we can't have any meetings. And last evening, I've received a letter from the government reminding us certain things. I will issue it to or circulate it to members. They've reminded us that according to the Bills Committee's Chairman's manual, it says clearly that the scrutiny of bills should be done expeditiously, and it should be completed within 3 months. Now, there are several stages of our scrutiny, and we've entered the clause-by-clause scrutiny, and then we will have to reserve time to discuss whether the members and the government will move CSAs, and then we will also have to resume the second reading debate. So all these takes time. My goal is to finish the scrutiny by the 7th of May. And then it takes another 9 days before we can get back to the House Committee. And then the government has to give notice to have the bill having resumption debate at the Council. Mr. Frank Chan, can you tell us what are your expectations of the work? As we said in our letter, we have expressed our worry. We understand that actually, a number of meetings have been held, and I understand that everybody wants to do the best job. But it seems that we are running short of time. If we want to implement co-location in September when the XRL is commissioned, and as what the Madam Chair has pointed out, we have to reserve enough time for a debate at the full council. That's number 1. Number 2, we have to allow sufficient time to make notice or notify the Council. And we have to reserve time for the Bills Committee to prepare a report to be submitted to the House Committee. So we have to finish the scrutiny of the bill by early May. So that's how we should proceed from the perspective of how to do the best job. So I hope that Madam Chair and members of the Bills Committee can consider this timetable proposed by us. I understand that you want to do your best in scrutinize the bill, but I hope that you are mindful of the expectations of the public that the XRL can be commissioned in September. So we have to do our work according to that timetable. Any members who would like to raise a point of order? 5 members. So please, the first one who would like to raise a point of order. Anyone else? Mr. Chair, Mr. Yu Si-wing, Ms. Story Lee. Mr. Lau, did you raise your hand? Mr. Kenneth Lau, you didn't. Okay, 8 or 9 members. 8 members. Okay, you'll go by one. 2 minutes each. Ms. Tanya CHAN. Madam Chair. And I want to raise a point of order in relation to the rules of procedure. You said 9th of May. No, it's a 7th of May. It's a Monday. So how many more meetings will we have? How many hours of meeting will we have before that date? And also, maybe the government's letter can be shown on the screen for our reference here, because we do have the equipment at the building to do that, to do the projection. Now, we also said that there should be visits to be conducted, and Mr. Eddie G asked for a visit to the shotgun stabling sidings and also the area as listed in the bill. We will conduct such visits before the 7th of May. Well, you haven't even started conducting the trial of the train again. So this is for your information. Dr. Fernando Zhang, please switch on my mic. Madam Chair, this is a Bills Committee, and you draw a line. And you said that by the 7th of May, we must finish our scrutiny work. The reason being that, as what the Secretary said, after the scrutiny work has been completed, there are still many procedures to be gone through, and we have to reserve enough time to work on this bill so that we can commission the train or the XRL on target. Shouldn't we have sufficient time for our scrutiny work? And if we want to compress the work of our scrutiny, you are actually putting the cart before the horse. We are talking about a bill which may be unconstitutional. We raised the issue back in 2007, and we said that co-location might not be constitutional. Now it's 10 years later that you propose a package to us, and this package that you're proposing today is different from the proposal last year. And you are asking us to compress our scrutiny work so that you can have more time to do work that is outside the scrutiny scope. And this bill may be unconstitutional. Isn't that very outrageous? Ms. Claudia Mel, you said that we should scrutinize the bill expeditiously. This is the Legislative Council, and we must do proper gatekeeping role in drawing up legislation. You are now drawing a line yourself, and it's not been endorsed. And you said that we can finish our work by the 7th of May. Well, why don't you suggest that we should complete our work today? It's even safer to do that, right? The Bar Association said clearly that the basic responsibility of the Legislative Council is that it should not pass any legislation which is in breach of the basic law. You are turning a deaf ear to that. Bar Association's opinions should be well respected. What kind of legislative council is this? You just want to tie in with the government's work. And you should not plunge the Legislative Council into a state like that. How can you do that? This is unprecedented. You can't do that. Ms. Alice Mack, do you have a point of order? Well, okay, I'm raising my hand. Well, you will be put on the queue. So, members, please be succinct in what you say. Mr. Gary Fan, I haven't, my mic hasn't been switched on. Yes? Madam Chair, if you want to do it expeditiously, but then you are allowing the Secretary to spend a few minutes to repeat what we have said and also what the electrical should do. Now, if the Secretary sent you a letter last night, shouldn't you be circulating the letter to us as soon as you can? The economic benefits of the XRL are called into question, and the co-location is in breach of the basic law. But the government hasn't been giving us satisfactory answers to all these issues. If you want to speed things through, then you can't explain why the travel industry bill was not being tackled expeditiously. It was proposed first in April 2017 and the work hasn't finished yet. So if we want to speed things up, why doesn't the government respond to our questions expeditiously?
I'm very concerned about the economic effects, so please report the figures, and I request them every time, but the Secretary says it will only be disclosed at an appropriate time. So the appropriate time should be during the scrutiny of the bill. Then the committee can do actual scrutiny work rather than have it endorsed, bulldoze it through the assistance of the establishment camp, and then only submit the economic figures for the co-location arrangement. You have been asking that, but the Secretary has not responded. Next, we have Mr. Eddie Ju. Thank you, Chairman. I have 3 points. I hope the Chairman should not squeeze legislators. You should also squeeze the government, the officials. They have not provided documents. They only say they will submit it later. Second, can you imagine when you reach Clause 8, we need 30 seconds, first round, 20 seconds, the second round, and so on? I understand you have a goal. Everybody has a goal. But your goal needs to align with a principle, that is, each clause-by-clause scrutiny should be given reasonable time. And third, we will be moving into the mainland delineation of the mainland area in our clause-by-clause work. So I hope the government, when we deal with Clause 8, we can go to a certain area of the express rail link to conduct inspections, because it would be too late by that time. Next, Mr. Hall Jie. I want to emphasize that we are dealing with the rules of procedure If you're talking about administrative issues, I understand there should be a separate arrangement. It is accurate that we have not been so conscious of time control in other bills, but we have never heard of examples where we spend so much time on the forward, and I think this is a very abnormal situation, and I can understand Chairman is paying close attention to developments. Now, we have heard all about the concerns regarding the basic law. There isn't any further controversy. Now, if you're really sincere about handling the issue, why don't you endorse the bill and then seek a judicial review rather than filibustering and stalling? It's pointless. You have to understand we have a responsibility to scrutinize the bill. Mr. Yu Xing, just now Mr. Fan said that we're stalling over the bill's work, and why do we have to speed through the co-location? That's two different issues. The tourism bill covered a wide range of issues, and it is at least 3-4 times as thick as this bill, so the two bills are different. Now, if you look at the Tourism Authority, they had 24 meetings, we have 12 meetings, so to use that analogy is not appropriate. So if you will refer to the Bills Committee manual in paragraph 1C, the chairman can make decisions. So the chairman's decision has not transgressed the handbook chairman of Bills Committee's conditions. Now, regarding paragraph 2.9 in the manual, it says that reopening of discussion on issues on which there has been full deliberation should not be allowed. Now, I think Chairman has given sufficient time for the opposition camp, and they have repeated their stance repeatedly, and the government has also responded. If there are new issues, they can raise these questions. If there are new questions, Chairman should allow them time to raise the new questions, but there haven't been new questions. And we should go into our procedures as scheduled. Starry Lee, Express Rail Link is a significant investment for Hong Kong, and the public expect us to complete our work before summer recess. If we are to complete the scrutiny before summer recess, we need to consider how much time and when the Bills Committee should complete its work in order to complete all the scrutiny by summer recess. So I think under normal circumstances, the Bills Committee typically don't draw deadlines, but this is very abnormal. We have an inordinate amount of filibustering, and just the budget, we cannot allow Hong Kong to face a fiscal abyss. We do need to set time constraints, and that is reasonable. So while we set time constraints, we could convene extra meetings, and regarding actual inspection, I have no strong views. I do think we need to visit, but we heard from Mr. Eddie Chu that he wants site visits. Well, I think he did visit, but he didn't use the opportunity, and he used that opportunity to demonstrate rather than inspect. That's irresponsible, and I hope the public should understand. They should not call for inspections, but don't make use of the opportunity. Ms. McMakin, Chairman, could you wait for Ms. McMakin to finish? I'm not going to interrupt, and then I wish to clarify. Ms. Mack needs to speak. Chairman, the last time I spoke was the first question in the previous meeting, and if we could not complete the scrutiny, then would the Express Rail Link commence, or would it commence later? And Mr. Frank Chan said the commencement date could not be ascertained. So I stopped asking any questions since then. But now, after so many meetings, some people deny filibustering, but there's actual filibustering, and I had been silent. I heard somebody say that the Bar Association viewpoints are very important. Now, if you can say that, then you need to be consistent. In the last legislative year, the Bar Association had a view on copyright amendment, but you didn't say that that view was important. When we scrutinized the bill, they were picking the minutiae over A and N, and they are insisting A is not a singular description. So there are a lot of inconsistencies, and we're not even going to argue about that. It's very obvious that they're just trying to filibuster. But frankly speaking, Chairman, you don't need to get upset. I understand you are looking at the big picture. You want the bill to be completed as soon as possible. But we also want to have the express rail link commence on schedule. But we have to demonstrate to the public we have done our best. And if the Bills Committee has all kinds of stalling and filibustering, then ultimately the public will suffer. The society will suffer. So I think the public know. The last rule of procedure, you have to clarify, I'd like Ms. Dari Lee to clarify. Does she know that on the last inspection to the express rail link, the government did not take us to the concerned area? Is she aware? I want to clarify. All I saw was that Ms. Eddie Chu was demonstrating, and he's asking for another inspection. That is the facts that I observed. Mr. Chan Ginbo, do you have a rule of procedure? Oh, sorry, Mr. Chan. It's Mr. Chan Ji-chun first. You're always late. You need to come and attend. Did you press the button? What is your question? Do you have a rule of procedure? Well, we drew the line. The last two, Mr. Chan Ji-chun and Mr. Chan Ginpo. Chairman, you have emphasized that the handbook of chairman of the bills committees need to deal with the bills in a reasonable amount of time, and there should be 3 months at most. But we see there are a lot of complexities and controversies. A bill can go and last up to 18 months. Now, when we enter the clause-by-clause scrutiny phase, and if you ask Mr. Yu Siwen, if there were outstanding issues, there was still opportunity to clarify before going back to clause-by-clause scrutiny. That is the ideal. We cannot be led by the express rail link commencement date. If they say, well, we cannot make the September time the deadline, and it can only operate in December, and will that give us 3 months time? Why do we keep talking about copyright amendment? It's because Zhang Sing at that time he could not foresee how long it would take, and he set some constraints. We are now dealing with clause by clause and questions with legal binding effect. And does that mean if we ask more questions at the beginning, we have less time to ask questions at the end? But you have to allow for sufficient time given the complexity of the bill. Next, Mr. Chan Ginbo. Thank you, Chairman. Well, we've had the biggest question we have over the meetings is whether it's constitutional. They had meetings of more than 10 hours with the DOJ. So the fact is, no matter how many more hours you spend on it, we cannot get a decision. We have to wait for the courts to rule. You have to launch a judicial review. But I don't think we can conclude by the end of the year if we continue like this. But the public expect commencement in September. They want convenience. They want co-location. So a responsible chairman should make a tough decision. As a matter of fact, the High Court made a ruling that the chairman needs to regulate the meetings. It has to be fair, orderly, and the chairman can stop the debate and can set time constraints. So if we know how many minutes for each clause we have, or how many hours for each clause, then we can have a very healthy discussion time for each clause, and we won't be spending too much time in front and insufficient time towards the end. Okay, I've heard every question regarding rule of procedure, and let me explain our work schedule. Currently, we have 6 more meeting dates, and if necessary, we can add meetings. I will consult the secretary, the secretariat, and we will come up with a list of meeting dates. You can mark your diaries. Let me finish. Next week, we cannot convene a meeting because there's a special FCE. So legislators from different camps, they can use that time to meet with myself and the deputy chairman, and the target is to complete by 7th of May, and we have 6 more upcoming meetings. If necessary, we can add extra meetings. I don't think this is a complex bill. It's not complex at all. It's actually very concise. Actually, just now the pan-Democrats have been talking about policy. They say it's unconstitutional, or they question the economic effects. We have had plenty of discussion, and we shouldn't struggle over this. Now, we have scheduled 2 hours for today, and we've already used up 30 minutes, so I think we need to continue with clause-by-clause scrutiny. Well, the new legislators haven't visited. Can you arrange? Well, we can also meet with the Transport Housing Bureau after the meeting. Can you have them answer now? Oh, I will raise that question formally. So, new legislators would like to visit. Can you arrange for that? Thank you, Chairman. Before I answer, could you allow me to respond? Because they had mentioned the government's actions. We'd like to state clearly that when I wrote to the chairman, I had no intention to pressure the committee. We just, when the government team has the responsibility or obligation to raise their concerns, and during the scrutiny work, as with other livelihood issues, we need a timetable and a roadmap. And of course, we respect the procedures, and we believe that with the chairman's leadership, we can have sufficient time, reasonable time, to conduct the scrutiny. So if you need extra meetings, the government team will do our best to accommodate. Now, regarding the new legislators who wish to visit, we had already said that we can make arrangements.
And after the meeting, as we know, the construction work for the XRL is proceeding in full steam, and we have to work out the visit time with the relevant parties, and then we will arrange for a visit as soon as we can. Well, there is a deadline for finishing the work of the Bills Committee, but then you can't even give us a date on the visit. So let's continue with the clause-by-clause scrutiny. Can you show the government's letter on the screen? Can you project the government's letter on the screen? I will circulate the letter to members now. Members, well, how many hours in those 6 meetings? 12 hours. If needed, we can convene extra meetings. I will now circulate the Secretary's letter to everyone. Now let's resume the clause-by-clause scrutiny. Madam Chair, we haven't finished the discussion on the rules of procedure and the point of order. Madam Chair, your approach may contravene rules of procedure 76. I think we have finished discussing the rules of procedures and the points of order. Let's resume the clause-by-clause scrutiny. First one, Ms. Tanya CHAN. Well, we are finished with the discussion on the point of order. Clause-by-clause scrutiny. Ms. Tanya CHAN. Now, are you going to ask a question? If not, then I'll jump to the next member. I have explained we will not further discuss the point of order. Let's resume the clause-by-clause scrutiny. Well, if there aren't enough meetings, we can convene additional ones. I said that I will talk to you next week on the timetable. All right, clause-by-clause scrutiny. Ms. Tanya CHAN, are you going to ask a question or not? If not, then I'll ask another member. 3 minutes, Ms. Tanya CHAN, you are asking for the first round. Madam Chair. Well, we're finished with discussing the point of order. Ms. Tanya CHAN, I have a lot of questions. Please, ask your question then. No. 76 of the Rules of Procedure. At 76, 7. On interpretation. My understanding that this question has not been raised, but the legal advisor had stated in her first letter, and the government has made reply, and that is on the laws of the mainland. If we look at the Shenzhen Bay Ordinance, in the definition there was the laws of Hong Kong, and that was having laws of Hong Kong enforced in a non-Hong Kong area. But now this time we are in a place of Hong Kong enforcing the laws of mainland. In the preamble that term appears. So in the interpretation, can you give me an explanation why there is no definition on the laws of mainland? And this question was raised in the first meeting or in her first letter of the legal advisor, and then she didn't follow up on that issue. So can the administration explain why this is the case? I have 3 or 4 other questions, and in relation to 76(7) of the Rules of Procedure and also the laws of the mainland, can you give me a response? Mr. Pang and Ms. Tanya CHAN, thank you very much for your question. For the Shenzhen Bay Port, Hong Kong Port Area Ordinance, there was a definition or interpretation of the laws of Hong Kong. Back then, the laws of Hong Kong's definition was in line with the laws of Hong Kong as defined in IGCO Cap 1. So that's why we haven't replicated that in our present bill. So if the laws of Hong Kong that we propose are in line with the definition of Cap 1, then we don't need to repeat it here. What about the laws of mainland? Because in the first letter of the legal advisor, bracket 6, that question was raised. Mr. Pang, well, I heard that you were not feeling well. I hope that you will recover soon. So you are done with your question? Laws of the mainland, and also the legal advisor, maybe he would like to follow up. Mr. Pang, thank you. The legal advisor's letter was not exactly asking about the interpretation of the laws of mainland. When we drafted the bill, we have looked at the present legislation of Hong Kong. The laws of mainland do not. When they appear in other ordinances, there were no interpretation. There was no interpretation, so we are abiding by the same approach. I wonder whether laws of mainland have ever been enforced in Hong Kong. So this time we are having the laws of mainland enforced in Hong Kong, and there is no interpretation. I don't think it's appropriate, and because actually the present bill is like a mirror, reverse mirror of the Shenzhen Bay port ordinance. So if we don't have a definition of the laws of mainland which are going to be enforced in the Hong Kong area, then that may be problematic. And the legal advisor said that the laws of mainland were not defined in the bill, and the clarification is sought, and also there is a question of the scope. So that's why I'm following up on this point. The second round, Dr. Chen Chung-tai, 2 minutes. Thank you, Madam Chair. I would ask a question about the Shenzhen Bay Port Ordinance. In the interpretation, there is the definition of public authority and includes any tribunal, board, commission, committee, or similar body that is established by or under an enactment other than a court. Well, in the Shenzhen Bay Port Ordinance, there is no there is not the term regulatory body there. So do we need a definition or interpretation of a regulatory body? Because we are concerned as to whether the public authority has to be defined or interpreted here. But how come that the Shenzhen Bay Port Ordinance doesn't contain the term regulatory body, but then for the present bill, the public authority interpretation does include the term regulatory body? Thank you, Dr. Chang, for your question. In the definition, statutory authority, the term public authority is included. And for statutory authority, there are 2 main types, and that is Roman letter A, and that is the power imposed on chief executive, public officer, public body, or public authority. And then Roman letter B, then is a public body, public authority under an enactment. And also, we will have an interpretation on the regulatory body as well. We have taken reference from the provisions in the Shenzhen Bay Port Ordinance in drawing up this bill, and regulatory body actually appears in the Shenzhen Bay Port Ordinance. Dr. Fernando Zhang, second round. Madam Chair, this is a point of order. According to ROP 76, bracket 7, it says that a bills committee shall consider the general merits and principles and the detailed provisions of the bill allocated to it, and may also consider any amendments relevant to the bill. Madam Chair, we don't have any amendments yet. We may propose certain amendments, and after the scrutiny work, maybe the amendments may even be proposed by the government itself. That happens in many bills, and there may be amendments moved by the members too. So, pending all these being moved and discussed, you are drawing up a deadline, and you said that we will be finishing the scrutiny work by a certain date. This is irresponsible. The implications of the bill are far-reaching. And if you say, or the pro-establishment members said that for the issues or the points we raise do not warrant discussion, well, please point those out. If we think our concerns are inappropriate and should not be discussed, please point those out. Dr. Zhang, I have already said that the scrutiny work will be proceeded with in phases. We've spent 17 hours on discussing the merits and principles, and we still have to reserve some time for discussing amendments. So that's why we have to work with a timetable. I said we will be holding 6 more meetings, and if necessary, extra meetings can be held later on. I will distribute the work timetable to you, and next week you can meet with myself and Mr. Horace Zhang and the Secretariat to discuss. This is unprecedented, and this is most irresponsible. I must reprimand you here. Mrs. Starry Lee. point of order. Let me respond to Dr. Fernando Cheung. In fact, well, generally speaking, we would allow everybody sufficient time to speak in the Bills Committee meeting. But then things have become abnormal, and the committee is subject to filibustering here. So I think, Madam Chair, you have no other choice but to do this, and I think this is a responsible approach. Dr. Cheung, well, was quoting the ROP out of context. He said it was unprecedented. But when we discussed the ivory trade bill, Mr. Kenneth Leung was the chairman, and he also drew up some deadlines, and he only allowed me to speak for 3 minutes. It's not like what Dr. Fernando Cheung is unprecedented. Mr. Kenneth Leung had done it before. Maybe he should ask Mr. Kenneth Leung whether he has done it before. Well, let's not go around in circles. Well, Mr. Kenneth Leung, it has to do with my reputation. I must respond. Please give me a chance to clarify, because I was criticized just now. Now, in relation to the bills on ivory trade, the question has been repeated for 5 times, 6 times, and in fact there was a broad consensus on the bill among the members. All right. I didn't set any deadlines. I just said that you are repeating your questions, so no more such a question anymore. So I got it. All right. Let's not further discuss the point of order. So let's continue with the clause-by-clause scrutiny, second round. I think, Madam Chair, you have been conducting the meetings most unfairly, and you haven't allowed Dr. Fernando Cheung to discuss point of order, and you didn't allow him. And then Mr. Chen Hanbang raised a point of order, and you allowed him to speak. What are you talking about? It isn't filibustering. The questions that we raised have everything to do with the law.
We had heard a lot of recommendations by councillors, and the government is not sincere in listening. I've heard it for so long. There have been a lot of recommendations, and you choose to ignore them. So we're now in clause-by-clause scrutiny. Are there any areas of improvement that can be amended? Will you submit a CSA? Secretary? Thank you, Mr. Au, for your feedback. The government team, from start till now, we are very sincere in listening. If we hear any proposal that is worthy of our review, we will do so. Well, if they say they are willing, then I hope that in our upcoming scrutiny they can consider our views. At least you said you would consider. But I have not heard from your team saying that you would consider the members' proposals and it's worthy of an amendment. I hope to hear that. Otherwise, it's a waste of time. No matter how many hours of meetings you have, Mr. Au, no matter how many hours we have, it's useless. We have not finished scrutiny and you're talking about amendment. You need to wait till at least we have completed the scrutiny. I wanted to follow up on the commencement date. The West Kowloon doesn't have a mainland port until the bill takes effect. Now, if the mainland staff, if they want to work in an area that has not been established as a mainland area, then they have to comply with Hong Kong laws. But I want to ask, why in the Shenzhen Bay Ordinance is there clause 15 saying that after the commencement date is published, they will exercise the laws, and the response was that implementing some of Hong Kong laws at an earlier date would allow Hong Kong staff to do preparatory work. So on this occasion, the mainland staff, where they don't have mainland laws applicable and they want to do preparatory work, they don't need the laws to authorize them. And the second question is that the government has already blatantly stated that mainland staff, they can enter Hong Kong and work in the mainland area that has not been established as a mainland port to do preparatory work. So I want to know how many mainland staff have arrived to work in this area to do preparatory work that has not been authorized as a mainland area. And the work, does it have to be conducted under two sets of laws? I'll give you an example. If they have to bring some guns to Hong Kong, can they do it before the commencement date, or do they have to wait till 12 midnight when the law takes effect? We understand the society's concerns and legislators' concerns. So when we scrutinize the bill, when the bill is not endorsed or after the bill is endorsed, before the effective date, there is no mainland port area, and mainland law enforcement agents cannot enforce any laws. I'd like Mr. Au to elaborate on the preparatory work. Thank you for the question. The mainland staff, if they do preparatory work in Hong Kong, they have to have a permit authorized by the immigration, and their personal items have to be inspected by immigration, and the majority of staff entering Hong Kong are computer specialists. Well, why did Shenzhen Bay had to use Clause 15 to allow Hong Kong staff to do preparatory work, and whereas in this Express Rail Link they don't need that arrangement? Could you respond? Why we don't have that clause? I think my answer was clear. It's because we know the society's concern and it's sensitive. So after the bill takes effect, then we will have the mainland port area. So in our plan, we do not allow mainland officials or other officials to do any work before the port is established. Mr. KWOK and then Eddie Chu. Two questions. Abbreviation and commencement date. I don't understand why this bill is why is the commencement date designated by the THB secretary? Because the whole collocation, it is a customs, a security issue, it's an immigration issue, and even the Security Bureau secretary is responsible. So why do we have Mr. Frank Chan, who is unfamiliar with this work, doing this job? That's the first question. The second question, in interpretation, the mainland, Ms. Leung Mei-fan had mentioned she had some concerns about the interpretation of mainland. Now, if we look at the definition of mainland, it does not it does not say the part. It says any part, and the definition here we see it means the part of China other than Hong Kong, Macau, and Taiwan. So how did they come up with a definition of mainland, and how come we have a new interpretation? Well, we asked the question about commencement date numerous times, so you can answer briefly, Secretary. Thank you, Mr. Chu. Mr. Chu asked why this bill and the Shenzhen Bay proponent are different. Shenzhen Bay was proposed by Security Bureau, and co-location, the proponent is THB. This arrangement reflects a basic fact that co-location bill is a cross-boundary infrastructure facility. It is a project that benefits the public. So allow me to finish. The main purpose is to draft bills to draft co-location bills that are convenient to the public. Well, the definition of mainland, thank you, Eddie Chu. When we drafted the bill, we made reference to other laws. In our current bill, we have a mention of mainland, and Mr. Chu's definition of mainland, the major difference lies in the phrase any part of China. We don't want to use this concept to mean parts of China other than Hong Kong, Macau, and Taiwan. So, from this perspective, that is how we approach the definition, Mr. Leung Yu. Before I asked a question about commencement date, I asked what was the situation. And I would like to follow up. First, you said that the mainland staff are engineers, computer specialists. I'd like to know how many of these people are in Hong Kong, and what sort of insurance do they have, and the administrative staff, when will they enter the premises, and how are they regulated? Especially, I'd like to understand what the security arrangement is. We understand that it's a highly secure area. Their security system, is it different from Hong Kong, and how do we handle the work transfer? Thank you for the question. In West Kowloon Station, there are mainland staff doing preparatory work. We said they are engineers. Our understanding is that if changes according to the workload, it does not exceed 100 people. There's a few dozen people per day. I'll have my colleagues supplement. Could you repeat the question about security? You have engineers working in Hong Kong. What is the insurance coverage they have, and security the procedures in place? And we understand it's a sensitive area. How do we ensure that the workflow, how do we ensure that it's smooth? So I'll respond to the security and insurance issue. So the engineers, their insurance is covered by the company they work for. So the employer has to provide for insurance. Any supplements regarding security? Thank you for, the security. We have Hong Kong border control and mainland border control. The demarcation is very clear. And in all our land border control, the arrangement is the same. Mr. Alvin YEUNG. One important aspect of the bill is to differentiate between Hong Kong and mainland border control areas. We can discuss that when we get to that clause. I want to ask about the interpretation. We have not clarified what do we mean by mainland institutions. In Annexes 1 and in Item 6, there is a footnote, and we see that mentioned there. And of course, that coincides with the cooperation agreement. So in our bill interpretation section, if we have not designated the mainland designated institutions, and we just rely on the Clause 6 of the Schedule 1, if there are any changes that would affect the mainland staff in the border control area, what kind of people can work there, I'd like to ask the government, if that situation arises, do we need to change our laws? Well, if there's an amendment of the cooperation agreement, cooperation arrangement, that question has been raised before. Allow me to respond first. When we drafted the bill, we were aware that some clauses needed a legal basis, and we had to write it into the bill. Regarding the cooperation arrangement, if it does not need a legal foundation, then it's not included. So any amendments of the cooperation arrangement, it would depend on whether it is relevant to the bill. If necessary, we have to come to LegCo for amendment. And regarding the footnote in C550, I'll have Mr. Pang respond. Thank you for the question. If you look at the clauses 347, the cooperation arrangement is talking about on 18th of November, the arrangement was signed, and it was endorsed by the NPC on the 27th of October. And if there are any other amendments to the supplementary document, to the supplementary agreement, we can consider whether an amendment is needed. Mr. Kong Zhen-Yu, first round. I'd like to consult the secretary. The secretary rose through the ranks of EMSD. We had to follow, Mr. Frank Chan had to follow up on a lot of escalator problems. So now in this post, there is a question. The mainland port area, they have different escalators. If there are accidents, the first question we have is, what mechanism will be deployed to deal with those problems? Where are the escalators? Thank you, Mr. Kong. In the design of the bill, we understand that West Kowloon Station, the building facilities are standardized. We cannot have standard A and standard B.
So on issues of regulation, of safety aspect, so we would be following the Hong Kong standards in our design and regulation. In relation to CAP 618, I would like to ask, you want that the lifts in the mainland port area will follow the Hong Kong standards. Say, if there are problems or major incidents happening at these lifts, so if the who would be the persons doing the maintenance? Is it Hong Kong registered technicians? Will mainland technicians be involved? I think so, right? Secretary, thank you. Mr. Roy Kwong for your follow-up question. Under Hong Kong's laws and guidelines, those not listed in the law cannot undertake the relevant works. If, say, in cases of emergency, if, say, the lift within the MPA is involved in an accident, and if it happens in Hong Kong, you call the police. But what about the MPA? If mainland people see such accidents happening, then they will do something, right? By the experience of the Langham Place incident, we know that the on-site situation and the relevant information is very important. We'll have to find the evidence, collect the evidence immediately after the incident. Now, say if the mainland technicians are handling the escalators and doing certain things at the escalators, would that be a problem? Well, I think that has to do with the reserved matter. Well, let's go back to the bill, please. Well, he is expert. Please ask him to answer. Thank you, Mr. Kwong. Thank you for your question. My present capacity is not the experts in lifts, but in any case, I'm bound to respond. In relation to the scenario you mentioned, say if within the MPA some accidents or incidents happen, we, together with the mainland authorities, will put in place emergency response measures. What matters most is we have to safeguard lives. So can I ask Mr. Au to supplement in, say, emergency situation? What is most important is to protect people's life and safeguard safety. Well, he hasn't understood my question. I am asking about the criminal liability that may be involved. Okay, Ms. Tanya CHAN. My question has been clear. I am following up on the legal advisor's letter back then. So can the government give me a complete response? So please don't use up my time to ask the legal advisor to answer. According to the handbook of the chairman 2.15, the chairman can seek the advice from the legal advisor, but please don't use up my time for doing that. I would also like to follow up on Mr. Alvin YEUNG's question. I have looked through the schedule myself. In Schedule 1, it touches upon mainland authorities stationed at the mainland port area. It appears 3 times, 723 bracket 3 and so on. It appears. How come that is not included in the interpretation section? You've raised that question before. I'm asking 2 separate questions. Mainland authorities stationed at the MPA, why don't you include that in the interpretation section? And also laws of the mainland, what scope does it cover? As the legal advisor said, asked the applicable scope of laws in the mainland in the mainland port area. From the law drafting perspective, laws of the mainland appear in articles, sections, or clause 6. There is a regarding measure or regarding clause, the application of the laws of the mainland and of the laws of Hong Kong, the mainland port area. We haven't given it a interpretation in relation to the mainland judgment's reciprocal enforcement ordinance. There is no interpretation of the laws of mainland, so we can use a general interpretation of that term. So can the legal advisor say something about this? I'm also worried about the note, since it's part of the law, but then no interpretation was given to it, and only the interpretation of the cooperation arrangement was only used. So if we have to amend the provisions in the future, does it mean that is like what Article 16 of the cooperation arrangement says, that these submissions have to be approved by the CPG? Well, I'll ask the legal advisor to comment on all these in one go after we are finished with the scrutiny of certain clauses. Madam Chair, I hope that you can consider this. When a member raises a question, and if the legal advisor's response is relevant, so please ask the legal advisor to respond immediately. So that would help the member and the administration to respond and discuss the matter further. And if you ask the legal advisor to respond, say, several meetings, later in the subsequent meetings, and that would not be good enough. I believe that legal advisor has jotted the notes, but then it doesn't work for the other members, so we will be say out of touch with the issues. Now the meeting will end at 10:30. How many more members have lined up to speak? 10 members would like to speak. So 2 minutes to 3 minutes for each person. And after that, maybe I'll ask the legal advisor to respond. I don't get it, Madam Chair. Why don't you allow the legal advisor to respond now? Because there are so many people on the queue. Well, my question is related to this previous question. Well, the procedure is that the legal advisor will be given time to give a consolidated response on this part. No, he shouldn't be doing that. Well, so legal advisor, please respond briefly to this point, please. Thank you, Madam Chair. On two questions. First is what we mean by laws of the mainland, and maybe the government can give a written response to members whether such a term is used in other ordinances in Hong Kong. Second point, according to the mainland law system, in the mainland's legal system, there are different tiers of statutes or regulations, and the government's response is that all applicable laws on the mainland apply here, so the government can clarify on that point. And in relation to Schedule 1, quoting the cooperation arrangements, in the last meeting, I also mentioned about the drafting style of the bill, and the government chose to put the provisions of the cooperation arrangement in the schedule, and it is not writing these provisions actually into the bill. So under Article 6 of the cooperation arrangement, there is a definition of mainland authority stationed at the mainland port area, and it is noted, it is put in the note. Another way to do it is to put it in the interpretation section. Mr. James Doe, I would like to follow up on what I asked in the last meeting. The last meeting, the government said that at the West Kowloon terminus there is an area designated as the MPA, and it is designated by the council, and Hong Kong laws should originally apply to this area, the MPA, but then the Hong Kong laws will no longer apply to the MPA under the bill. Now, if Hong Kong laws can specify that Hong Kong laws will not apply in the MPA, so does it mean that if mainland laws are to apply there, then only CIQ laws will apply? Can the council enact such laws to take this part out of Hong Kong's jurisdiction? And can we specify that only CIQ laws of the laws of mainland will apply? Can we do that? Mr. Wong, thank you. Madam Chair? Thank you, Mr. To, for your question. Let me try to respond it from a legal perspective. First, we have to understand that for laws enacted by the SAR government, as pointed out by the member, they should be in line with the basic law. Mr. Zhang has also mentioned earlier that for this bill, this seeks to implement a transport policy as mentioned by Mr. Chen. And from the preamble of the bill, there is indeed some background to this because there was this cooperation arrangement signed, and then also there was a decision of the MPCSC made last December. And these two facts have to do with the MPA to be designated in the WK as, and apart from some reserved matters, mainland laws will be applied. So this is the actual background to the bill. So in case in enacting local legislation, we are deviating from such arrangements and decisions, then that will not be in line with the reality or real situation. But then, even so, we can do it from the legal perspective. Mr. Ted Hui, there is a statutory authority including license, permissions, and so on, and that has to do with clause 7.3. And in clause 6, we have the MPA, the Declaration of West Kowloon Station Mainland Port Area, and in the reserved matters, then some obligations and rights will not be affected, and the pre-existing obligations and rights will not change because of the bill. But then for the statutory authority, is it handled differently? And my question is, why is that different treatment? What is the legal basis? Do you have any specific examples of rights and obligations under the statutory authority specified here? Can you share some concrete examples with us? Who to take the question? Madam Chair? Who will take that question? Mr. Pang. Mr. Hui, for your question. Statutory authority appears in 7.3b. For 7(2), in relation that there should not be any changes in relation to pre-existing rights or obligations because of subsection 6(1). Can you share some specific examples? For example, if a person has registered as an engineer, but for his registration qualification, can that still be valid within the MPA? Well, our view is that for this registration, for non-reserved matter, that would not be valid in the MPA.
You have exceeded your time. Let's say an accountant, they are registered under 7(3), but it's registered outside of Hong Kong. So if they work inside the mainland area, and would their registration take effect? Well, according to your interpretation, while you have exceeded your time, you can follow up in the next question. No, this is inside interpretation regarding the statutory powers. Could we follow up in clause 7? Well, Chairman, you don't allow officials time to answer. I'm just talking about the interpretation. Why do we have to wait till clause 7? I'm asking what the obligations and the responsibilities they would have under the statutory powers. Well, we have mentioned different statutory powers: license, registration, permissions. So different people are given permission and authority granted by the chief executive and so on, and we want to handle their obligations and rights that they enjoy. So after the commencement date, if they how would that be handled in the mainland areas? So these pre-existing obligations and rights can be covered in the mainland area. That is a brief response. So let's say a registered escalator maintenance staff. So it would depend whether it is a reserved issue or a non-reserved issue. Mr. Lam Teng has pressed the button, but I drew the line. Everybody had, well, I had asked at the beginning who has questions, they need to raise their hands. Where did you draw the line? I still have a lot of questions, Chairman. What do you mean by drawing the line? Well, we have to conclude clauses 1, 2, and 3 today. Now, at the beginning, I had asked who had questions regarding clauses 1, 2, and 3. Did you just press the button? Were you late? Oh, yeah. Well, it's hard for me to allow people who arrived late an opportunity to press the speech button. You asked your questions. You were present. Mr. Fan, Gary Fan, you asked twice. You had asked questions twice. You should not have a restriction on the speaking occasions. Why do you say that we have finished asking? We have questions regarding definitions that are not included. For example, we talked about which mainland law enforcement officials will be working in Hong Kong. Well, aside from what has been written down, we would like to ask questions. There are also questions regarding material that have not been included. Well, I had already asked who has questions. Did you press the button, Sharon? You have to switch off the button before I can press the button again. So when they cannot answer my question, I have to follow up. You are also a legislator. You have also pressed the speech button before. You've asked twice. You had asked twice previously. I've waited in the queue for an hour. You raised so many rules of procedure questions. You should not use establishment camp time and allow the government officials to avoid responding. Well, in order to save time, I'll have Mr. Lam Teng ask 3 minutes. Thank you, Chairman. This is my first round. Thank you. I want to follow up on Mr. James To's question. Our legislation on this occasion, we're taking West Kowloon and some part of it and designated a mainland area. So that gave rise to one question, and I'm not sure if it has been asked before. So if we can legislate and designated a mainland port area, and the government says there is a legal, that's an important legal basis. So in the future, can we endorse any laws to amend this legislation and take this mainland port area demarcation? Can we remove the mainland port arrangement? Is it feasible? Because if the whole legal basis is based on the Hong Kong legislation and this part has changed, then will the mainland port area legal status also change? Secretary, thank you, Mr. Lam, for the question. We understand establishing a mainland port area is to facilitate co-location. The infrastructure planning and operations had undergone detailed preparation and consideration. So we do not foresee the mainland port area being changed, because the whole, I understand, Secretary, I'm asking about the legal question. So legally, can the area be changed? Can it the whole area be made void? We don't see any need in the policy, so the bill has not made for such an arrangement. So of course, regarding the legal basis, we can have DOJ respond. Mr. Wong? Well, actually, the whole bill committee put forward to the Legislative Council has one purpose. It's to implement co-location, and that requires local legislation. Yes, that is necessary. I'm just asking, if LC has a different decision, we amend the law, then what happens? Then we cannot support the cooperation agreement where there was a decision made by the NPCSC that endorsed the co-location. That means co-location arrangement will be made void, so the area of the mainland port area might be changed. Is that my understanding correct? The legal outcome would be similar to not being able to endorse this bill. Mr. Kong Jun-Yu, the second round. Just now, Mr. Fan said Mr. Frank Chan said he was not an escalator expert. So now I want to talk about the Langham Mall. After the accident, the engineer was arrested because of perversion of justice, because they removed some material after the accident. So I want to ask, when we connect to the mainland port area, one important tool are the escalators, and that is Mr. Frank Chan's area of expertise. So if a mainland official tampers with the material and is suspected of perverting the course of justice, will they be arrested? I can answer that. Please note in the blue bill, C546. Clause 7.2 says that the related facilities, including fire safety storage facilities, escalators, and so on, other than facilities and equipment provided by the mainland authorities stationed at the mainland port area themselves, or exclusively used by them in carrying out duties and functions pursuant to this cooperation arrangement. So these facilities will be regulated by Hong Kong laws. I'm saying, if a mainland official in an emergency situation, let's say they have touched the material in a scenario like Langham Place, they had tampered with the material, and it interfered with the investigation of the accident. I'll have Mr. Ao respond. Thank you, Mr. Kwong, for the question. We can come back to the actual situation. Let's say there is an escalator accident or incident. The mall security staff or other management in, let's say, a station or elsewhere, they will control the crowd. They will prevent the incident from deteriorating. They will have safety staff inspect the equipment. So, and that activity will be dealt with by Hong Kong laws. You haven't answered my question. Will the Hong Kong police arrest mainland officials based on suspicion that they tamper with evidence? Well, given normal situation and maintenance, if there's negligence by the maintenance staff, or their maintenance is not up to standard and they have contravened the Hong Kong escalator laws, then my understanding is that under C546 it would be regulated by Article 7. So if there is a deliberate destruction of the escalator in the mainland area, they damage the screws or they injure people, that would be a criminal incident. Then it doesn't come under Article 7. So that's why I have to ask Mr. Frank Chan, because he understands that Cap 618, the contractor has to maintain the escalator. So if the mainland official, if they say, tell you to don't bother with the maintenance work, continue to use the escalator, will you arrest that person? Let me allow me to elaborate. Essentially, in West Kowloon, according to the cooperation agreement and the relevant laws, basically all the facilities and buildings are, all the laws there are the Hong Kong laws, so theoretically there should be no mainland officials involved. But we have the mainland port area. We have a mainland staff. Time's up. Are you going to arrest that person? Mr. Kwok Hung. On the last occasion, I had mentioned a question. According to Article 7, Bracket 5 of the Cooperation Agreement, if a Hong Kong passenger or a Hong Kong authority or institute, if there is a civil suit, a civil case, and if the mainland institute is facing a civil suit, is that covered under Article 7, subclause 5? If there's a civil dispute, if the mainland institute and the Hong Kong side, passenger or whether it's the MTRC, how would that be handled? Because there's a loophole here. Have you looked at this issue? Who can answer that? Thank you, Mr. Kwok. The bill and cooperation agreement have not specifically dealt with this. If we do have civil disputes, we'll handle it according to typical legal rules. What do you mean? If there is a civil suit and mainland authorities versus, let's say, a Hong Kong party, well, the courts will have to examine the cooperation agreement. These civil suits, Hong Kong courts will have to exercise the jurisdiction. So you have not spelt it out, the mainland versus Hong Kong party, what would happen.
Okay.
You have to make that very clear, because I believe there is a loophole there. Wesley, is it that you want to say something? Mr. Wong. Thank you, Madam Chair, and thank you, Mr. Kwok, for your pursuing of the matter. Before Mr. Light supplements further, I have to say something about the premise here. Mr. Dennis KWOK referred to a civil dispute, and it will depend on the subject of the civil dispute. If it happens within the MPA, and that is being handled in Clause 6, and that has to do with the laws and jurisdiction in the mainland port area, so there is no question of a loophole. And then in clauses 7 and 8, those were discussed. It depends on whether it falls under the ambit of reserved matter or non-reserved matter. If the issue has to be handled by mainland laws, by a mainland court, then we would follow the mainland law. I won't quote specific examples. Mr. Dennis KWOK referred to a scenario whereby the mainland authorities is up against a Hong Kong party. No. That falls outside the scope. No, that's not necessarily the case. Say if I am a private party and I have a civil claim with the mainland authorities, I'm not I'm talking about tort and contract and other civil proceedings. So if that happens within the MPA, so do you expect how do you expect the courts of Hong Kong to handle it, or do you expect them to take to have jurisdiction over this? This is unclear. If it is not the individual against the authorities, then we'll have to look at clause 6 and to see whether it is a reserved matter. Let me ask Mr. Lai to supplement. Since Mr. KWOK has raised a new point, I will allow time for the government officers to make a full reply. Mr. Lai, thank you, Mr. KWOK, for your question. Let me repeat that for the bill and cooperation arrangement, the points raised by Mr. KWOK have not been covered, and that is maybe and that is on the civil dispute between a mainland organization and a passenger or individual. But should this be called a loophole? No, I don't think so. May I refer members to a discussion paper presented by the government to the council. In relation to the MPA, the government has taken on board the model adopted at Shenzhen Bay Port to avoid duplication of jurisdiction and to avoid having a legal vacuum, so to speak. So the full set of mainland laws are enforced in the MPA. So it's just that for some exceptions or scenarios whereby we want to avoid difficulties in civil relationships. So some of the matters are regarded as reserved matters, which are written into 7(5) of the cooperation arrangement. This is not a loophole. The government has detailed thinking on it, and we think that in the MPA the full set of mainland laws should apply. I'm not going to follow up on that further. Please, the administration, consider the possible scenarios of a civil dispute that I mentioned. I think the courts will have a headache in deciding on whether they have the jurisdiction over such issues. Please consider that. Mr. Jeremy Tam, have you pressed the button? You just press the button. Mr. Tam, second round. Thank you, Madam Chair. I asked in the last meeting about law enforcement. Let me repeat what I said last time. If, say, this incident happened, this crime happened on the train compartment, but the train has stopped, and then it starts to go to Shek Kong, and then we found that there was this crime committed. So how are you going to handle this? You can be more specific in your reply, because I'm quoting a very specific scenario here. Say on the train compartment, there is a smuggling and there is illegal immigration. The person, say, is hidden at the bottom of the train or somewhere in the train compartment. And when the train goes to Shek Kong, and this is happening, so how would you enforce the law at that particular moment? So if everything happens in Hong Kong, then that's simple. The police will ask the train to come to stop, and then maybe go onto the train compartment and collect evidence. But then if the train is in motion going to Shek Kong, and it's crossing the different port areas, if it is an ongoing incident, it's happening when the train is in motion to Shek Kong. So how would you handle it? I don't believe that mainland public security officers will enforce a law across the boundary, or will authority to ask the train to go back to the West Kowloon. If there is any party making that order instruction, who is that party? So Mr. Au, please. Thank you. Madam Chair, thank you, Mr. Tam, for following up on this. Madam Chair, can I be allowed some more time to explain things clearly? Let me try to talk about this in several aspects to allay Mr. Tam's worries. Now, in terms of the design of the platform is enclosed. There is a 2.5 meters or 8 feet a fence enclosing the platform, and after the train has come to a stop and towards the two ends of the train there is also some fencing, so there isn't a great possibility of people entering that particular part of the platform. In relation to the passenger flow, when the train comes to the WKS train, all the passengers should leave the train and go to the arrival hall, and then the railway staff will check the train compartments immediately to make sure that there are no people or suspicious articles being left in the train compartment. Mr. Tam said that if the train has to go to Shenzhen, then there are still a few more steps to be taken. The train personnel has to be cleared by the mainland authorities. So in other words, the mainland staff will go onto the train compartment to check the staff and the train compartment before the train is allowed to leave for Shenzhen. And also for the timetable schedule, I mean, it will be compiled in a very strict manner. Only Hong Kong trains will go to Shenzhen, and they will be stabled there. And only Hong Kong people will be on the train compartment, and the Hong Kong staff will hold valid documents. They are called designated or dedicated staff, and all the train departures are fixed, and if there is any change, it has to be approved by the train staff. And changes in the train schedule have to be made known to the Hong Kong staff. Now, so if the train goes from WKS to Shenzhen, it will go all the way to Shenzhen, and it will not stop in the middle. And the Shenzhen, the control center will be supervising all these. And when the train gets to Shenzhen, there will be also some fencing 3 meters high on the platform, and there are CCTVs, alarm systems installed to monitor all these movements. And all the dedicated staff on train, when they disembark, they have to go through the immigration and customs stations at Shenzhen, and the customs staff can also go on board the train to check whether there are people or articles left on the train compartment. So with all these procedures in place, what Mr. Jeremy Tam mentioned is not very likely to happen. The risk here is much, much slower than that in other port areas. And there is also a port liaison mechanism. Both parties will exchange intelligence all the time, and they would strengthen cooperation if needed. Thank you. Mr. Gary Fan. Third round, 1 comment and 1 question. Now we are coming to the first part of the bill, short title and commencement interpretation, and then also the interpretation reserved matter and non-reserved matter. It's difficult to cover all the 25 interpretations here within such a short time. I am concerned about 1A and 2, and that is C546 on the cooperation arrangement, and it is said that the people in holders of valid permit issued by the both governments can pass through the mainland port area to other places within the West Kowloon Station to carry out duties and functions. Save as stated above, these personnel should comply with the laws of their mainland inside the mainland port area. But my question is, for these designated personnel, many of these will actually be what is stated in Article 7, and they are the engineer staff, etc. The government said that the bill doesn't go against Article 18 of the Basic Law because it says the targets for these bill is not all Hong Kong people, so it's not generally doesn't generally apply to Hong Kong people, so it's not unconstitutional. But then if a large number of people will become a designated personnel, so what does the government mean by the arrangement does not apply to all Hong Kong people? So you've used up your 2 minutes. So please make a brief reply. Thank you. C546, Article 7(1), designated personnel, when they carry out their duties, they are in the capacity of designated personnel, and they're protected under Hong Kong laws in doing that. So apart from carrying out duties and functions there, then they are there just as individual persons. So that's very clear. I would like to follow up on an earlier question posed by Mr. James Toll. The bill seeks to put in place co-location arrangement, and you said that based on the cooperation arrangement, all the provisions are there to facilitate it. So if it is for facilitating co-location, why can't you state clearly that only CIQ laws under mainland laws are applicable here? Because mainland laws are so different from Hong Kong laws, as is known to everyone, and the laws do have the laws on provoking troubles and picking quarrels, etc. And there is also the new law slandering the country. So why don't you consider this? Why don't you consider, say, expanding the scope of the reserved matter? Who to answer? Mr. Wong, let me answer Ms. Mo's question. The SAR government is proposing this bill and seeks to implement co-location. That's correct.
And just now, Mr. Frank Chan also mentioned there is a policy objective to avoid the overlapping of the two jurisdictions, and that would include very serious security issues. So that's why at the policy level we won't be using Mr. To's description, that is just in the mainland port area implementing CIQ. And because of that reason, but we have a lot of overlapping, and you have enlarged the reservation area. Wouldn't that make it clear? We can delineate what we have reserved. Next, Mr. Fernando Cheung. Chairman, the mainland port area definition, of course, includes West Kowloon Station and the train carriages themselves. Usually these borders are specific borders, but now we have moving borders. So we heard scholars say that might be a smuggling express line, because when you stop and move towards Sekong from a mainland port area, it would convert to a Hong Kong area. So all of a sudden we have immigration entry action. So a person or goods would enter Hong Kong area in a blink of an eye. Now, we are also aware that SARS has occurred in Hong Kong, so if an infected person or animal is in the carriage, in the train, and we need to implement a quarantine, then that carriage, when it's mobile and moving, it's in the mainland port area, and Hong Kong laws cannot regulate that. And if there are infected people or animals that need to enter Hong Kong areas, and if they, while they are moving, an infection occurs, the virus is dispersed. That is a big public health loophole. I don't. Now, typical immigration ports are not handled like that. So, why don't you include public health issues in the reserved matters? Mr. Ao, thank you for the question. Regarding the two borders, the demarcation is very clear. There is no ambiguity. Now, if we look at the bill regarding the carriage, it is very clear in clause 5.2. So aside from these area conditions, the rest are just mainland areas, and when when the carriage stops at the Shek Kong, while it's within Shek Kong, or while making a journey from Shek Kong stabling sidings to West Kowloon Station, yes, that is clear. We had discussed that on the last occasion. So when it's moving from Shek Kong, then it changes from mainland port area to Hong Kong area. Yes, that is made clear. It's also very clear that it's a smuggling express link. Let me move on to the public health issue. Now, when we deal with communicable diseases, Department of Health staff are responsible. They take body temperature and also conduct immediate action. Now, if we have individual cases, we have procedures to deal with. If we have a major outbreak, I understand that the Department of Health is in talks with the mainland counterparts. When these occur, there will be cooperation between mainland and Hong Kong to strengthen we might have to prohibit infected people from embarking. So in Hong Kong Station and mainland station, we'll strengthen the inspections. Now, if we detect when people arrive in Hong Kong, if it occurs in Hong Kong, we'll deal with it in Hong Kong. If it occurs on the mainland, they will deal with it on the mainland. So the details are still undergoing discussion between the mainland and Hong Kong Department of Health counterparts. Mr. Leung Kai-Cheung, I want to ask, following up Mr. Fernando Cheung's question, if there are animal or person in the carriage, is it possible, do we allow any animals to embark the train, aside from humans? Secretary, thank you for the question. There might be animals. If you take a look at the blind, they need the guide dogs. We allow the guide dogs to board. Well, if a passenger takes the express rail link and wants to visit relatives, and they bring live poultry, you understand that poultry virus, the contamination rate is very high. If you tell me live chicken, geese, and duck are allowed to board, I'm very worried about that. Can you clarify that? Thank you for the follow-up question. In existing railways or cross-border arrangements, live poultry are prohibited. Live poultry. What I want to ask, guide dogs, in your regulations and sub-regulations, is it specified that you said the poultry is not allowed? What other animals They might not be guide dogs. It could be a pet. They want to ship a pet from mainland to Hong Kong. There might be quarantine arrangements. Let's say I have the pet in the cage and delivered to Hong Kong. It can be hand carried. Is that allowed? Secretary? Thank you, Chairman. Thank you, Mr. Leung, for the detailed analysis. When we take the express rail link to cross-border and taking the train, buses, or even walking across the border, the arrangement is the same. If you take a train, there are train arrangements. The Hong Kong operator and mainland operator, they have a cooperation. Our plan is to not allow live poultry and animals, with the exception of guide dogs. Aside from that, customs also conduct checks for contraband and prohibited goods. Mr. KWOK, Chairman, I disagree with your rough handling at the beginning. I want to ask, in the rights and obligations, we want to know that in the future port area, originally the SAR had obligations and rights. We are a signatory to the Human Rights Convention. We allow freedom of speech and so on. So, after the commencement date, if the SARG wishes to comply with the Human Rights Convention, and we want to safeguard Hong Kong people, freedom of speech in the port area, let's say if they call for an end to a one-party ruling, that would be enshrined in our in Hong Kong, and there would never be any limitations of speech in Hong Kong. So, with the implementation of co-location, will we lose that right? If we lose that protection, and every year when we report to the Human Rights Convention, when we report on our freedom of speech, what do we tell people? Do we say in the SAR there is an area where these are not safeguarded anymore? We cannot Mr. KWOK, let me express my view. We understand what you're saying. Is it Mr. Wong? Thank you, Chairman. Well, first of all, if we look at the bill, the existing rights and obligations, that's in Part 3. It does not cover what Mr. KWOK described. But given Mr. KWOK's question, even though that does not arise out of Part 1 of the bill, the SARG stance is clear. We also gave written responses. The situation is, if a tourist who chooses to travel to mainland, they have to go through customs and immigration. So whether it is the West Kowloon mainland port area or they wish to enter other mainland facilities, their rights have not been deprived and diminished. The situation is the same. Well, of course it's diminished because they had originally enjoyed a right. Well, will you go back to the UN Human Rights Convention and will you update the conditions of freedom of speech in Hong Kong? Well, a lot of people have asked this question. Mr. Alvin YEUNG raised that question. Well, Chairman, you cannot say that we did not make proposals in the last 2 hours. I've heard 2 or 3 proposals. Mr. James Toh said a CIQ issue, even though the government response was that it's not in line with reality. Could it be dealt with in future amendments? Second, Mr. Tanya CHAN said Shenzhen Bay Clause 15 issue, that ordinance helps us clarify the effective date and when arrangements will take effect. And I even suspect that Mr. KWOK's query about how to deal with civil suits and so on, and I recall either the Secretary or Mr. Pang said that because of sensitive issues it would not be added. But we need to deal with the commencement date. Otherwise, you wouldn't, in the Shenzhen Bay Ordinance, from the long title to Clause 15, there would be that connection. Your response to Ms. Tanya CHAN was, those were just editorial notes, but Clause 15 clarifies that connection. So in your proposal, will you add the relevant clauses to deal with these controversial issues? And lastly, I want to add one point. I see in CBC 463-1708, in response to the legal advisor, you said there's a definition of remedial issues. So will you include that in the interpretation? Time's almost up. You have a little bit of time. Thank you, Chairman. Thank you, Mr. Owl, for the question. In the whole bill, drafting of the bill, the government team were aware that society and legislators were concerned about certain issues such as mainland law, commencement date, civil suits, and Mr. Owl talked about investigations. As a matter of fact, these are everybody's concerns, but the whole government team had considered a lot of legal rules and policy objectives. So we want to focus our bill. We feel that the current arrangement is appropriate. Well, we're at 10:29. We cannot extend because the education panel is scheduled next. We still have a lot of members with questions. They are in the 3rd and 4th round. So I will invite the Secretariat to give us a timetable. So next week we don't have time for meetings, and whether they are pan-Democrats or establishment, we can talk about the timetable.
We have certain issues to follow up on, including the point made by Mr. Jeremy Tam on Check Kong. Supplementary information has to be provided. The government, I believe, has heard clearly your questions and views. You make a judgment as to whether you need to answer them. The next meeting will be on the 23rd of April, 4:30 to 6:30. Please be there on time.